Good morning and welcome to the meeting of the H.E.L.P project. Today we will be talking about the legal aspects of images and how to use them. I'm Cristina Manasse. I'm a lawyer admitted to the Court of Milano. I have experience in art law and intellectual property, also digitally, advising the GLAM entities in relation with the use of art, use of photographs, and so on. So images and general legal principle is the topic of today. Some of the things to think about. In your daily work, you are using images for uploading, downloading, for reproductions, for putting them in the web virtual tours of your entity, and so on. So there is a huge amount of use of images, and they are ruled by a bundle of laws, among which copyright is only one of the rights granted to the images, in the sense that they are also protected by other rights. We will have to distinguish between photos and photographic works, because according to the creativity that has been involved in the shooting and in the research for the project, there may be a different kind of level of protection granted by law. And we will see that photos and photographic works bear economic rights, so the rights of exploitation, and also moral rights. We will try to identify who is the right holders, or there may be also right holders, in the sense that there could be images with inside other artworks that will have to identify as far as concern the right holders. The display of photo is another topic that will be addressed, both in the sense of can we display the photos that we own, or can we display the photos that we own in relation to the privacy laws that are in place in the various jurisdictions, and then some legal topics and inputs about the use of images in the social networks. So let's start about identifying which are the main legal sources. So the main one is the Berne Convention, which provides the minimal protection and leaves to the member states the possibility to identify which are the images that have to be protected under copyright law and how are they protected. So I would say the limits and the goals of the protection. There are many directives that have address topics related to the images, so the copyright protection, the term of protection, and the right holders. The WPO copyright treaty, which is of really great importance because it's the first treaty to talk about the access. So considering that we are going digitally, we have already gone digitally, and so we have another way of using photos and producing photos, the word access is absolutely relevant for these topics. Civil codes also protect artworks in general, and in some cases also the images. But bear in mind that photography and photographs have been, I would say, put at the level of artworks only on second time. So it has been a sort of battle to protect images and to identify them as artworks. So then we have, of course, the Code of Authors' Rights or Copyright, the privacy law, and the GDPR regulation, the data protection regulation. And in some jurisdictions also it is necessary to consider whether the cultural heritage code, if relevant, is applicable to images, because we could have collections of images of historical and artistic importance. So in some cases, in some jurisdiction, we will need to identify whether this is applicable and with which limits. So the basics concerning images. If we go to the copyright general rules, we know that copyright protects the works which are results of the intellectual activity of the author. So they have to be original, they have to transmit the imprint, the individual choices done by the author, and they have to be expressive works. What does it mean? It means that they have to show and reflect the personality of the author intellectual creation. So they have to transmit something that to the viewer, to the user of the images, and they have to result in distinctive original works. So not to be infringing the rights of somebody else using somebody else's images, not even portion of the, unless there is a sort of limit considered by the law. And if we look at the decisions of the court and we wonder whether there is a specific level of creativity, we will have to say that there isn't a mathematical criteria for defining whether it's creative or not, but it has to be decided case by case. So it's mainly a case law. So if we compare the different jurisdictions, we can say that United Kingdom and US law are more generous in the protection of photographs. So the limits are not so restrict like in the EU member states. The authorized system tends to give copyright to photographic works. So the definition is photographic works. In EU, we have, on the other side, different kind of photos, because we distinguish between works of art, so photographic artworks, simple photos, and documental photos. And according to the different definition we can give, or the judge can decide to define the work, the different is the protection granted to the author. And so different it's also the level and the kind of rights that are granted. So different level of creativity means different terms of protections, both in the length of the protection, both in the sense of the rights that are granted to the author or to the right holders. And then in another case, we have also to remember that the simple photos have the limit that they are not granted moral rights. But let's try to define how do we distinguish between photos or photographic artworks. So in these photos, in this slide, we have two simple photos. They are simple reproduction of reality, a chair, some things for the home. So there is no effort, no intellectual creativity from the author. It's just a mere reproduction of a fact. So we would say that the simple photos are reproduction of persons, of facts, of reality, and there is no particular effort of intellectual creativity, so no particular choices, no artistic decisions. In these slides, we have the three cases: the simple, the documental, and the artwork. So the simple, we say that the creativity is absolutely, in the simple reproduction of reality. In the documental photos, we don't have creativity at all. It's just a photo of a document, of a paper. So it can be like this in a music score, or it can be the cover of a book. It can be a paper of a bank. There is a case also on the check of the bank. They are photos, documental photos. So it's just technical drawings and so on. So they are just documenting and taking the photo of a paper, of something that is really existing and doesn't need a creative effort from the author. In the case of the artwork, so photographic artwork, which is the one on the right, which is a photo by Piero Mollica, Diagonal Blue of 2015, we have choices, because we have choices made by the author. So we can say that in this case, there is the transmit of feelings by the author, because, for example, here we have a building, but the author had decided how to take the photo, the angle, the light, the contrast between the blue and the white of the windows, and so on. So there are choices done by the author that make us understand that there is a creative work. So this is the main distinguish between the three kinds of photos. So can we say that if we have a sort of iconic photo, there is no choice, so no creativity? This is a famous case that took place in England about the route master bus that is crossing Westminster Bridge. And this is the photo that was challenged by another photo that it's, I would say, similar to this. There is the usual route master bridge on the bridge. It's in black and white with the route master bus in red. So the party that was defending from infringing the copyright of the original photo said that iconic photos like this are not creative. Can we say that it is true? In this case, the judge decided that there were choices like the angle of shooting, the light, the shades, the effect achieved with the filters, because the author worked on the filters to make the bus more red. The balance of the feature, the composition itself is creative. So it means that it's protected by copyright. So even if they are iconic photos, like they could be the photo of the Duomo in Milano or the gondola in Venice, they could be creative in the sense that they have done with particularly efforts, intellectual efforts, choices, decision, which could be both artistic or technical, and therefore they have to be considered like photographic artworks. When we talk about photos and we make the distinction between photographic artworks, simple photos, or documental photos, we have to remember, as we said before, that they bear authors' rights in the sense that they are granted both economic rights or moral rights. The economic rights are those that are generally defined as rights of exploitation, which have a sort of negative effect, but or sense, meaning. But the economic rights and the ones that are mainly concerned with the activity of museums or archival and GLAM entities are the one of reproduction, publication, distribution. So to make the images accessible. So it's a sort of economic exploitation. They have a term of 70 years, during the life of the authors, plus a term of 70 years after his death. They can be transferred, but it's important to say that the transfer of rights must be done through an agreement. And I would say that the oral agreements are not applicable in the sense that you can have the proof, the evidence of which rights have been transferred. So the suggestion is to have a specific agreement where you can say which are the aims, for which purpose the rights are transferred, which is the purpose of the transfer, and which are the limits. On the other side of the slides and on the other side of the bundle of rights granted to the photos, there are the moral rights. The moral rights in certain jurisdictions are the right of authorship, so to be recognized as the author, the right of integrity in the sense that there cannot be amendments or modifications without the consent of the author, the right not to publish the work or to withdraw it from the market. There is no term, so while in the other there is a term of 70 years, generally here there are no terms, and they cannot be transferred, they cannot be even waived by the right holder. So as we said before, the photographic works are the one to which both economic rights and moral rights are granted and are at the top of the protection, I would say, scale. The simple photos are in a sort of in-between level. The term is 20 years after the death. And in the case of the documental photos, we say before, no moral rights, because they are not protected by author's right, they are protected by the general principle. So when we use or when we exploit the image, so we have a sort of use of economic rights, we will have to bear in mind that there is a moral right to be complied with. So the right of the author to prevent alterations, modifications, or to destroy a work has always to be kept in mind, because the use, so the right of reproduction, of dissemination, the right of loan, the right of reproduction, and so on, do not have to, I would say, challenge the moral rights that are granted to the author and to the work. But who is the right holder? The right holder in images could be first the author, because the photographer is assumed to be the author of the work, so the one who has done the intellectual property, I would say, efforts, intellectual creative choices, so he is the main right holder. But we have to consider that in some cases the works, so the images, can be commissioned, or they can be part of the activity done according to an employment agreement. So the suggestion is that for the commission works or for the employment agreement that have to do with images in museums or GLAM entities, it is important to define or to understand who is the right holders. So not the moral rights, because those rights remain always with the author, but the right holder for the use of, I would say, rights of exploitation, as we called them before. So unless it's differently agreed, the commissioning party will have the rights of use of the photo as well as the employer. So it is important to distinguish and to define, if we want to have a different regulation of the right holders in the images, who is the right holder. So I would suggest to have a written agreement with a clause that deals specifically with this topic. What if the image is has been taken in a museum and there are some other artworks inside the images? In this case, we could have what I call the circle of right holders, because not only the right holder as the author of the image we want to use, but there is also the right holder who is the right holder of the work of art which is inside the photo. So in this case, there could be the problem of authorizations, which could be authorization from the author of the work of art that has been photographed inside the photo, or, for example, of the custodian, in the sense of the museum, who is the place where the artwork is located. So we will have to check if there is a sort of conflict of rights, a conflict for the rights of use, if it is necessary to ask for specific authorizations or releases, and which are the limits. We could also have the so-called license to use. So also here, if we go to the online archive, for example, and we want to use a photo, we can download it from an archive, but there are the licenses, the agreement that you are signing. So you would have to specify for which use you want to have the image. And whenever you, for example, you look for an image on the web and you see that it's said in small letters, so in small wording, there could be copyright, in the sense that it's still protected by copyright, so there is a right holder. So the work is to check who is the right holder and ask for the permission, authorization, or a specific license to use the photo. And this applies to the state, to the cultural institutions, to the archive, museums, and so on. So the research of the right holders. When you buy a photo, an image, what do you get? Do you get the rights, the one we talked before, so the rights of economic use and exploitation of the moral rights? We said that the economic rights can be transferred, while the moral rights always remain vested in the author. So we can say that when you buy a work of art in Europe, in the European jurisdictions, you are not buying the rights unless they are specifically transferred. So you're just buying the corpus, so the work, which could be digital or in reality, but the specific rights of use or the rights, neighboring rights relating to the work, have to be specifically transferred. So as far as your activity is concerned, I would say that the main rights that are concerned and relevant for your activity is the reproduction in catalogs, the right of display, the right of public exhibition, the right of reproduction, the right of dissemination to make it accessible to third parties, and so on. So these rights should be indicated in a specific agreement, or there should be a clause. So whenever, for example, you download or you buy or you get in license a photo from a digital archive, you will have to detail for which purposes you need, how many times, how many copies, how many reproduction, and so on. So there should be a sort of checklist which are the necessity for your entity and which are the main rights. I would suggest to look for the future. So whenever you negotiate for the rights, to start thinking which could be the rights that you will be needing in the future. And this is why, to avoid a second level of negotiation, to try to identify immediately which are the rights that could be interesting for your activity. And whenever you use the work of art that you purchase and the rights that have been transferred, remember that there will be always the limit. So you will be able to use also an image which has been licensed within the limits of the agreement. And let's go to the other thing. When you purchase, so you purchase the image, you require the transfer, or you negotiate the transfer of rights. Can you display the photos? So when we talk about display, we talk about two different topics. First, we talk about the right to have a sort of exhibition to display the photos. And I must say that this topic has not been harmonized among the different EUA countries, in the sense that they can rule it in different ways. So I would say that there is a general principle. There is a general principle that commentators try to put the right of display inside other rights that are specifically listed in the copyright laws, so to be able to grant the possibility to display an image that has been purchased. But I would say that it's not harmonized in the EU countries. So you will have to identify in each jurisdiction how it's dealt with by the law. The second aspect of the display is the one who touches the protection of the image, of the right of image, because in some cases the images could be images as portrait of someone, or there could be the possibility to identify the people inside the image, and you will have to ask whether these images can be used, can be displayed, can be uploaded, for example, in the web page of the entity, used for a virtual tour, or so on, for advertising purposes, for communication purposes, and so on. So in this case, the jurisdiction have the so-called right of image, which is personal, is not transferable, and is absolute. So it means that it can be protected against all parties. And in these cases, the authorization is needed. So you can use the photo, but you will have to ask for the consent. And remember that the consent cannot be implied. So there is not an implicit consent. The right of image is also linked to the right of privacy, because there is, in some jurisdiction, is called right of image, right of identity, and right of privacy. And in the right of privacy, we will have to deal with not only the privacy laws, but also in the EU countries with the General Data Protection Regulation that has identified the sensible data, the super sensible data, and so on. So you will have to ask whether the photos that you would like to use for exploitation purposes are complying with the principle of the General Data Protection Regulation. And you will have to combine with the other right, which is the right of reportage, the right of information, the freedom, I would say the freedom. So in some cases, we said the consent of the person is absolutely necessary. In some cases, like in civil law countries, there are some events where the consent is not required because the reproduction of the image can be justified. And why? Can be justified because, for example, it is the reproduction of an event that is an event of public interest, or that has been taken place in a public place, or because it can be used for educational or research purposes, for needs of police of justice, like, for example, wanted person, because it's a person that is famous, because it's entrusted with a public office or task. So in these events, it's not a requirement to ask for the permission, the consent. But, for example, for the problem of events of public interest and events that took place in public, there are some interesting decisions by the European Court of Justice that have tried to identify what is meant by linked to events in public interest or that to take in public spaces. Because, for example, there is a case of a Royal Highness of a country here in Europe that was having lunch in a restaurant, which is a public space, but the photo was considered to be violating the rights of privacy because even if the photo was taken in a public place, it added nothing to the public discussion, to a social event. And even if a Royal Highness is considered to be a public person per se by birth, and so it's used to be exposed to public photos or public shootings in public spaces, this particular photo was not adding anything of interest, so of public interest, to a public debate. The public interest means that in certain cases, the right of information or the superior interest prevails on the private interest of privacy and of identity. So in these cases, the interest of knowing, or the interest of information, the right of information prevails. Another of the criteria that is considered by the judge is whether the person can be identified inside the photo or is just a part of the photo per se, in the sense that the photo could exist and could have a sort of individual existence, even if we take off the person that is portrayed in the photo. In this case, is incidental. The person is incidental, and the photo was not taken to have the reproduction of his image, but was merely incidental. So in this case, we can say that the rights of image, the right of portrait, have not been challenged. So it can be used without the necessity of asking for the permission. We said before that there are the rights that have to be transferred using specifically agreements. We talk about licenses that can be taken from online archives, and we said that there is a license where you will have to specify which are the purposes, how many reproductions, how many editions, and so on. So when we talk about these things, we're talking about contracts. So the main question is, are you using contracts? Are you using specifically contracts, or are you using, or you have adopted, or you have put on your website terms of service or terms of use? Why are we asking that? Because as we saw, talking till now, we have seen that there are rights of exploitation, or the right of use, the right of economic use related to the photographic works or to the simple photos that have to be indicated as specifically transfer. So there cannot be a sort of general transfer, and there should be in place an agreement, an exchange of correspondence, or a terms of use where you have defined which are the purposes for which goals and which are the rights that are intended to be transferred between the two parties. So the contract could be a specified contract, or could be, I mean, the ruling could be inserted in what is called the terms of service or the terms of use. So how are you dealing, for example, with the content of your website? How are you dealing with the possibility granted to the viewers to use such content, or mainly, how are you dealing with protection of that content? Are you specifying with specific clauses that in the terms of use or in the terms of service? Have you identified? So I would say that you should care, and you have a sort of checklist of things that should not be done and things that should be done. Starting from do not use images just because they are online and you justify their use saying they are online and so they are on public domain, they are free for use. As well, do not imply that there is a consent to use the image of a person that is portrayed in a photo, because the consent, as we said before, is not implied. And that do not justify the coincidence that could be between two photos that look different but are the same concept and the same idea, So check whether there is a sort of plagiarism or violation of what we defined before as the moral rights. So if you find images online, try to understand whether they are available, whether they are protected, whether they are can be used according to a license, and which license is applicable to that specific image. So what you have to do, you have to check the rights before using, before sharing them. Once you share them, you lose the control. So are you sure you want to share them? How do you share them? With technical devices that impede the downloading of the photos? Are there any protection means to impede the dissemination? Can there be some limits that you will impose? And for the consent, we say it's not implied, but there could be some exemptions. If you are not aware of the exemption or of the limit, it's I would say the suggestion is to have legal advice. On the other side of the coin, there could be some things that have to be done. So before use, check the images you would like to use for reproduction, for the catalog, for the billboard of an exhibition, for the advertising material, for the communication, for example, material. If they are for internal purposes, generally, and there is no commercial purposes, generally the principle is that they can be used. If there is a sort of economic value in this sense, there should be the respect of the rights and the necessity to ask for authorization. Are they in public domain? Are there mere reproductions with no creativity efforts? Can they be shared because they are under a Creative Commons license? Which is a license? Are you aware of the content of the license, and which are the limits? Are they protected? Are they showing portraits of people? I mean, is there a violation of the privacy principles? Are you complying with them? So check your rights. Who is the right holder? Which are the rights that you have been granted? Have you been granted rights? Is there an image inside the photo you want to use? So there is the so-called circle of rights and conflict of rights. Are there limits to the use? It can be a license with specific and detailed limits. So I would suggest that it's better to use contract and to apply and read the terms of use before downloading a photo, an image from the web, even from an archive which have granted you the photo. Is advisable to read the terms of use, the terms of service, because there could be some limits that are in addition to the license granted, and some limits that identify the limits applicable to the use of the content. Is there any contract in place with the author or with any third party? Who is the right holder of the legal rights of exploitation? Have I complied with respect of the moral rights? For example, are we doing a collage, a pastiche of works, of images, and are we complying with respect the protection of the moral rights? Or should we ask, or can we consider that this is, for example, a mockery, a joke, or something that can be, I would say, justified by the term parody that has been admitted by the Court of Justice? Is a parody, is not a parody, it's a fair use according to some jurisdictions. It's one of the free uses because it's for educational purposes. Can we put them on the slides for educational purposes? Can we put the slides on the web? So in all this kind, try to understand which are the limits, which are the rights, and use contracts, because in the contract you can place a clause detailing the limits to the user, the possibility of the rights that have been transferred, which are the rights you need for your daily activity, and try to avoid doing a sort of copy and paste of the term of use of other entities, because they have been construed and applied to that entity and not to yours. And in the kind of necessity for all these things, seek for legal advice, because it is true, and we saw that in this last year of the pandemic era, that we have gone digitally, and there has been the resilience of many entities that have made accessible all the content to the users, to the viewers, to third parties. but there are many rights that are involved in the use of this digital content too. And so I would say that it's important to identify which are the rights, which are the possibilities granted to the entities, and which are the better, I would say, use and way and procedures to adopt to grant both rights of the entity and of the users. Thank you so much for your attention. Thank you.